Abusia Dom Kuma Ewo Mrashebedwemu, led by Madam Patricia Apiaje, MP for Asokwa constituency. Omodi atudwa se ene nsemu a ekoso ewo Ghana ye court proceedings mu no ha adwen ye pa ni nyina ne se ne aban lawyer panyin attorney general Dr. Dominic Ayine de tumi a hye ne nsemu chichiri nkrofo a hye se enimre mu na niama a ekoso no emwa ema kabima minka bi amamu entimi nkoso pa ni nyina ne se na nsan a na former CEO Edema Buffer Stock ye Abdul Wahab Hanan chese ekochire no abra court amano permission so ntimi ntu kwan kohwe na pomuden de no call ya chese ehun nsem bubroja sanso na kwabna dubu ahe eni wona ekeka ho abronyem chese kwan a attorney general afaso a on handle sa cases ne de ekeka ho no ha adwuye pa chese omo abrobro so a enya asem ketua na mepese ye begibre ya kutie nsem ne bi yenso ya dwenkyire yemfa into comment section.
All of our compatriots lost their lives. 90,000 were displaced across 7 regions. In that dark hour, we supported the swift release of emergency measures and asked only for transparency, accountability, and fairness to flood victims in every region of this country. Today, we stand before you with a document and a regulation. The document is a letter from the letterhead of the Office of the Attorney General and Ministry of Justice, dated 1st July 2026, signed by the Attorney General and Minister for Justice himself, and addressed to the Governor of the Bank of Ghana. Copies will be made available to you. The revelation is what happened after the letter was delivered. A sequence of events that exposes a government constitutional case where the Attorney General directs illegality. The central bank refuses him and $350 million Ghana cedis of the people's money moves from the Channel Parliament, never approved. In this letter, headed Release of Funds from the Contingency Fund for the Emergency Flood Response Program, the Attorney General writes to the Governor of the Central Bank, and we quote his exact words: "I'm aware that the Contingency Fund is presently the subject of a garnishing proceeding." Ladies and gentlemen, the Attorney General of the Republic confirms in writing that the Contingency Fund, a fund established by the Constitution of Ghana, is under garnishing proceedings before a court of Islam. A judgment creditor has moved against the very fund from which Parliament approved $350 million for flood victims. Until this moment, neither the government nor the Attorney General had breathed a word of this to Parliament or to the people of Ghana. And what does the Attorney General do? Confronted with a court process against a constitutional fund, does he go before the court? Does he apply to vary or discharge the attachment? Does he plead a national emergency before a judge, as the law provides and as any diligent counsel would? No. He continues, and again we quote, "Notwithstanding those proceedings, it is my considered opinion the exceptional circumstances surrounding this national emergency and the overriding public interest in safeguarding lives and property warrant the immediate release of the approved funds." Unquote. He then advises the Bank of Ghana to give effect to the approvals and directives already issued and to release the 350 million from the contingency fund without delay. Then it is in his own hand. The Attorney General, aware of subsisting court process, directed the Central Bank of the Republic to proceed, notwithstanding it on no authority and his own considered opinion. In the Republic of Ghana, court processes are not overridden by the considered opinion of any minister. They are varied, discharged, or set aside by the courts that issue them and by no one else. Now to the revelation. The Attorney General's letter speaks for itself. It directed the Governor of the Bank of Ghana to give effect to the release of funds from the contingency fund, notwithstanding the pending Ghanaian proceedings. Yet the Ministry of Finance subsequently announced that the 350 million cedis had been released, while the court process remained unresolved. The unavoidable question, therefore, is how did the money move? One conclusion is difficult to escape. If the contingency fund remained under attachment and could not lawfully be assessed, then the emergency disbursement could only have proceeded through another public account. In other words, when the approved source became unavailable, an alternative source appears to have been used. If that is what occurred, then Parliament was never asked to approve the alternative source, and the constitutional requirements governing withdrawals from public funds were bypassed. Yet the Ministry of Finance official statement announced, without qualification, that the money had been released from the contingency fund. If the funds were in fact drawn from another account, then that statement did not accurately reflect what transpired. We say to the government, these are your records. The Ghanaian order, the Bank of Ghana account statement, the Controller and Accountant General transfer advice, all of it sits in your custody. If the 350 million cedis truly came from the contingency fund, as you told the nation, lay the records before Parliament and prove it. If it did not, then tell Ghanaians which account was used, who authorized the withdrawal, and under what law. Consider first the supremacy of the Constitution and the rule of law under Article 1, 2, and 125. When the court attaches funds by garnishing, the law freezes those funds pending the court's determination. Every lawyer in this country knows the lawful responses. Appear before the court, resist the order, apply to set it aside, or plead the urgency of the public interest to the judge. Public interest is an argument addressed to a court. A government whose Attorney General certifies his own exemptions from judicial process has placed itself above the courts. And a government above the court is a government outside the Constitution. Consider second, Article 177 and 178. Parliament's Finance Committee, acting under Article 1771, on 29 June 2026, authorized a withdrawal from the contingency fund. From that fund and no other, an authorization under Article 177 is not a blank check, cashable against any account of the state that the executive finds convenient. Article 178 commands in clear language that no monies shall be withdrawn from the Consolidated Fund or from any public fund of Ghana except upon authorization given by or under an act of parliament or as the Constitution provides. If the 350 million was drawn from your any account other than the contingency fund, then the approval Parliament granted was never executed. The withdrawal that was executed was never approved. And the Constitution and the Public Financial Management Act 2016, Act 921, which criminalizes unauthorized withdrawals of public funds, have been violated in broad daylight. Consider third, Article 88. The Attorney General is the principal legal advisor to the government and is responsible for the conduct of all civil proceedings against the state. His letter of 1st July 2026 is a written admission of failure on both fronts. As the officer responsible for civil proceedings against the state, he presided over litigation in which a constitutional fund of the Republic was attached, and there's no indication that the attachment was resisted or that any application was made to discharge it. As principal legal advisor, when the moment came to counsel lawfully and the nation on 29 June, the Finance Committee approved a withdrawal from a fund the executive knew, or that on the information available to us never occurred as prescribed. Concealment of material facts from Parliament, compounded by a false official statement to the public, strikes at the foundation of parliamentary oversight, the power of the purse, and the basic covenant of honesty between the government and the people. The minority therefore demands immediate and complete answers to the following questions. Which court is seized of the Danishef proceedings against the contingency fund? In respect of which judgment, debt, in which seat, and for what amount? When was the Republic settled? And what did the Attorney General office do about it? Did the government know of the, if so, did the Bank of Ghana decline to give effect to the Attorney General's directive? And on what legal advice? From which account precisely was the 350 million cedis withdrawn? On what date, on whose instruction, and under whose authorization? And the question that towers above all the others, by what law does an Attorney General considered to suspend the process of court of the Republic? The role of the Minister of Finance in this affair demands independent scrutiny by Parliament. On 29 June 2026, the Minister came before Parliament's Finance Committee seeking approval to withdraw 350 million cedis from the contingency fund. At that moment, one of the two things must have been true. Either the Minister knew that the contingency fund was already the subject of the share proceedings, and felt had become entangled in court conflicts. Matters become even more troubling if, as the information available to the minority suggests, the funds were ultimately released from an entirely different public account. If the Minister authorized or became aware of that alternative arrangement, Why did he not return to Parliament for fresh approval? Why did the Minister of Finance subsequently announce that the funds had been released from the contingency fund? Was Parliament misled? Were Ghanaians misled? These are questions that only a full parliamentary inquiry can answer. Let no one mistake this for a technical dispute among lawyers. When 350 million cedis of public funds moves out of account, Parliament never approved, under cover of an official statement naming a different source, outside every control that the Constitution and the PSN Act erects around public funds. The conditions for corruption are perfect. Which account was debited? What else sits in that account? And what other withdrawals have been made from it on the strength of executive instructions rather than parliamentary approval? Step back and observe the picture, ladies and gentlemen. A constitutional fund of the Republic was dragged into Ghanaian proceedings, and the government told no one. Parliament approved an emergency withdrawal without being told the fund was encumbered. The Attorney General, guardian of legality, overreached by directing the central bank to disregard a subsisting court process on the strength of its personal opinion. The money then moved from an unapproved account, and the Ministry of Finance announced to the nation a version of events that the government's own records would not support. The Attorney General's letter itself, referencing the telephone conversation with the governor that very afternoon and directives already issued, paints the picture of the government scrambling in panic to paper over a problem it should have seen coming and should have as inconveniences. It cannot claim to be resetting the economy while demonstrating to every investor, every development partner, and every judgment creditor that in Ghana, the state's accounts are managed by ambush, improvisation, and concealment. And they cannot look flood victims in the eye while the institution meant to protect the funds for their relief are at war with one another over whether to obey the courts. Ladies and gentlemen, offices of state are defined by their moments of pride. For the Attorney General, this was such a moment. But that moment did not begin with the letter of the 1st July 2026. It began much earlier. We are in possession of court processes relating to these Ghanaian proceedings. These processes revealed that the Republic was not ambushed. The litigation followed the ordinary course of judicial proceedings. Court processes were served. Procedural opportunities existed for the Republic to respond, to protect its interests, and where appropriate, to seek relief from the court. Yet, despite all these opportunities, a constitutional fund of the Republic became entangled in Ghanaian proceedings. That is the product of neglect. An Attorney General who presides over the attachment of constitutional fund has failed in diligence. An Attorney General who conceals that the attachment from Parliament had failed in candor. An Attorney General who directs the central bank to proceed notwithstanding those proceedings, on the strength of his own opinion, has failed in fidelity to the very constitution he swore to uphold. An Attorney General whose directive is so plainly unlawful that the Central Bank of the Republic refuses to carry. To carry it out had been repudiated, not by its political opponents, but by the institution of his own government. Let no one plead the emergency in his defense. The emergency demanded speed before a judge, not a coup against the court's process. Any competent Attorney General could have secured the lawful release of these funds within 24 hours by moving the court, disclosing the agency, and letting the judicial process work as it was designed to. The flood victims of this country deserved the Attorney General. They did not get him. The minority caucus accordingly calls on the Attorney General, a Minister of Justice, to resign forthwith. Should he fail to do the honorable thing, we call on the President, who swore an oath to preserve, protect, and defend this Constitution, to relieve him of office without delay. The minority accordingly demands, first, the Attorney General and the Minister for Finance appear before Parliament without delay to lay before the House the Garnishare order, the full record of the suit that produced the judgment debt, the letter of 1st July 2026, and every correspondence exchanged among the Attorney General, the Ministry of Finance, the Controller and Accountant General, and the Bank of Ghana concerning the attachment, the directives, and the withdrawal. Second, that the Governor of Bank of Ghana state publicly whether the bank declined to give effect to the Attorney General's directive, from which account the 350 million was in fact released and on whose instruction. Third, the Auditor General immediately conduct a special audit of the flood response disbursement from source to destination and report to Parliament. Fourth, the Attorney General resign or be removed. We shall pursue every parliamentary and legal avenue available to us, including motion for a full-scale parliamentary inquiry and recourse to the Supreme Court for the enforcement of the Constitution under Article 2 and 130. In conclusion, let us be abundantly clear. The minority stands with the victim of these floods fully and without reservation. Not one peso of relief should be delayed. And we shall support every lawful measure to get help to those who need it. Our issue is with the government that conceals court processes from Parliament, directs its central bank into illegality, moves the people's money through unapproved channels, and then tells the nation a story its own records contradicts. The greater danger to a constitutional democracy is when those entrusted to uphold the law decide that the law no longer applies to them. In this affair, the Attorney General presumed to overrule a court by arbiter. The executive presumed to substitute Parliament's approval with its own convenience. The Ministry of Finance presumed that an official statement could replace the truth. That is not the conduct of government committed to the rule of law. It is the conduct of the government that has begun to confuse power with permissions.